All right. Hi, everyone. It looks like it's about 4 p.m. my time, so I'm just going to go ahead and get started. I'll be kicking things off today because Christian is having some internet difficulties, which I'm sure we can all relate to. So for those of you who didn't attend on Tuesday, my name is Sarah Oakes. I am an assistant professor of law at the University of Louisville Brandeis School of Law, and I am very excited to be here for part 2 of our series on an introduction to international criminal law. And while last time on Tuesday, our first class was really about the fundamentals and the principles of international criminal law, today is going to be an overview of one particular entity that enforces international criminal law, the International Criminal Court. So let's go ahead and get started, hopefully. There we go. So I want to start with some highlights from last class as a very brief review. The first thing I want to, just so we can kind of ground ourselves in today's discussion and kind of flash back to some of the really important principles that are going to come up when we're talking about the International Criminal Court. So the first highlight I want to focus on was, we talked on Tuesday about international criminal law being a field of last resort. And I'm going to hit on that topic quite a bit today. You're going to be pretty annoyed by the time we're done. You will have that ingrained in your head. But what that means is essentially that international criminal law will only step in when states with jurisdiction over internationally recognized crimes either fail to prosecute, either because they don't want to or because they can't. And the second big part of the definition of ICL, international criminal law, is that it's focused on rendering individual criminal responsibility, which means our defendants are always individuals. They're never going to be states. They're never going to be entities. I got a question a little bit ago, and I think I might have seen this floating around the chat as I was answering questions last time. The ICJ, the International Court of Justice, the court that's based in The Hague, that is not an international criminal court. That is not a part of international criminal law, not one of the entities that enforces or creates international criminal law. The International Court of Justice is a part of the UN. It's an organ of the United Nations, and it settles disputes between states. It deals with public international law and primarily and exclusively civil law issues. So these look at countries' obligations to each other, as well as countries' obligations to their own citizens. And while some of the cases can touch on issues of criminal law, for instance, there's a genocide case that's before the court now, it does not deal with individual criminal responsibility. That genocide case, in fact, only looks at the responsibilities of states under the Genocide Convention. So it's still a civil law issue. It's a bit complicated, but I just want to clarify, ICJ is not international criminal law, for those of you who were confused on that. Second highlight from last time, 4 core crimes of international criminal law. These are the 4 categories of international crimes that we have. If they go beyond these 4 categories, they will not be prosecuted by the International Criminal Court, and it's unlikely they will be prosecuted by other international courts. So these 4 core crimes, again, are war crimes, crimes against humanity, genocide, and the crime of aggression. And third and final highlight from last class, international criminal law is applied by international courts and tribunals. These include the ad hoc criminal tribunals, which I'll be referencing quite a bit today, the International Court for the former Yugoslavia and Rwanda. Those are now closed. So there's unlikely to be a future ad hoc criminal court. However, we do have hybrid criminal tribunals that are prosecuting cases involving international criminal law. These are in places like Cambodia, prosecuting crimes that were committed in Kosovo. They've been in Sierra Leone. Those are still going strong. And then, of course, we have the big kahuna, the International Criminal Court, which we will dive into talking about right now. So just like I did with Tuesday's class, I really kind of broke this part of the series up into 4 guiding questions. Obviously, each of these questions, they're big ones. There's lots to unpack in each question. So let's go ahead and get started with this first question, which is, how is the ICC created and what does it do? So basically, what is this thing, the International Criminal Court? I've mentioned it a couple times, but what we have with the ICC is a permanent standing international criminal court based in the Netherlands that with the goal of prosecuting the most severe crimes under international criminal law. So how did we come to be? Well, I will say it wasn't an easy path, first of all. It took quite some time and it had some false starts before it finally got off the ground. But the creation of a permanent international criminal court was really strongly considered after the success of the Nuremberg Tribunal and the creation of the UN, the international ratification of the Genocide Convention. All of this happened in the 1940s, and there was a real buzz around international criminal law. But this buzz kind of dropped off fairly quickly, especially as tensions started building between democratic and communist countries, ultimately building up into the Cold War. So everything with ICL was kind of on pause during the Cold War. Once the Soviet Union fell and the Cold War was resolved, things kind of started picking up steam again. So of all countries, in 1989, Trinidad and Tobago proposed that the UN create a permanent court to prosecute drug trafficking crimes. Essentially, this is kind of the spark that led to the International Criminal Court, a court that does not prosecute drug trafficking crimes, ironically, but it did kind of kickstart the International Law Commission to draft a statute for this permanent international criminal court that was designed to prosecute international crimes and really kind of gain steam in the UN and ultimately resulted in what's called the Rome Conference. So in July 1998, representatives from 150 UN countries met in Rome to discuss the draft legislation for the court. And they spent 6 weeks debating, tweaking, talking about what this court's goals were, how it was going to be structured and set up, and all of the details. And after those 6 weeks, they ironed out this agreement, which they called the Rome Statute. And what this agreement did was essentially establish the first world court. It established a permanent institution. This court did not have any type of temporary mandate. It was meant for the long haul. It was going to be located in The Hague in the Netherlands, the same location as the ICTY, and the same location as the ICJ, as I just mentioned. It tasked the ICC with adjudicating the most serious crimes of international concern, and it put significant limits on the ICC so that it wouldn't kind of intrude into domestic criminal state courts. And at the conclusion of the Rome Conference, they had a big vote on this final draft statute. And out of all those countries that came, an overwhelming 120 countries voted in favor of the Rome Statute, a couple dozen abstained, and 7 voted against the statute. These countries who voted against the statute included the United States, China, Israel, Iraq, and several other Middle Eastern countries. So despite those no votes, a bunch of these countries, the ones that voted in favor of the Rome Statute, went back home. After signing the statute, they ratified it, they implemented it into their domestic legislation. And in July 2002, with the 60th state to ratify the Rome Statute and incorporate it into their domestic law, the ICC officially became the first international criminal court. Since then, many additional states have joined. And today, the Rome Statute has what's called 123 states parties. So I'll be using that term, states parties. That essentially means the countries that have signed on to the Rome Statute and the countries that are now members of the ICC. So of this, we have, 33 African nations, 19 Asian Pacific nations, 18 from Eastern Europe, 28 from Latin America and the Caribbean, and 25 from Western Europe and other states. Most notably, however, as we'll get to later, are the countries who did not join the Rome Statute. And these include really heavy hitters on the geopolitical stage, the United States, Russia, and China, which was a huge blow to the ICC from the beginning. So a little bit about the structure of the court. The court can really be broken down into 4 different units. The first 2, I'm not going to spend much time on. These are the presidency. This is essentially the executive branch of the court. It's run by a president and 2 VPs, all of whom are ICC judges and elected by the other judges. The second unit is the registry. They handle a lot of the administration of the court, as well as things like outreach for victims and public relations for the court. And then the first of the really important units of the court are the chambers. And this is the judicial unit of the court. It's composed of 18 different judges, all of whom are broken up into 3 levels. The pretrial chamber, or the PTC, that handles issues that arise, you guessed it, prior to trial. The trial chamber, which handles trials and sentencing, and the appeals chamber, which handles appeals both from the pretrial chamber and the trial chamber. Judges serve a 9-year term, and the chambers are currently in flux. We actually have 6 new judges coming in this year to replace 6 outgoing judges. So it's going to be a really interesting time to watch the ICC with this change in judgeship. Giving things away here. Okay, the other big unit is the Office of the Prosecutor. And this is the office that's responsible not only for prosecuting cases, but for investigating them, and deciding which cases to open in the first place. And so the chief prosecutor is one of the most important people in the court, probably the most important person outside of the judges. And this is another position that's currently in flux. So for the last 9 years, it has been held by this woman on the top, Fatou Bensouda from the Gambia. And she's done a great job, but she is retiring actually next week. And I honestly can't think of anyone who deserves retirement at this point more than she does. She's had a rough go of it, but she's heading out, and Karim Khan, a barrister from the UK, will be stepping in as the ICC chief prosecutor June 16th. So there'll be a lot to watch with the changes in the court. Okay, so I just went through these 4 different units of the court. You may be thinking, or this might not have crossed your mind, but there is something missing. There's something that I haven't touched on with this court that the ICC specifically does not have. And to really drive this point home, I want you to think that you've been arrested, you've been charged with shoplifting at a drugstore, say. You are allowed to go home, but you receive a summons to court. You need to show up to address these charges against you. You can bring a lawyer, but instead you just don't show up. You don't go to court. What happens if you don't show up? Well, people are going to come after you. And specifically, the police are going to come after you, and they're going to make you appear in court, and you'll likely receive a bit of a nice stay in prison. That's because in our domestic judicial system, the police are there in part to help enforce the courts. They serve as an enforcement mechanism for the court, and the police and the courts enjoy somewhat of a symbiotic relationship. This is not the same for the ICC. The ICC lacks any real police force. Despite the misleading picture, these are not ICC policemen. I think they might be security guards, but there is no ICC police force or other formal enforcement mechanism. And so this means they don't have really much of a way to enforce their summons or indictments or even their convictions, which means that they're entirely reliant on the cooperation of their state's parties. So all of those countries who joined the Rome Statute, in doing so, agreed to this. They agreed to do some of the work for the court. And these include things like arresting defendants who are indicted before the court, and finding them sometimes, turning over witnesses and disclosing evidence. So states parties really do have a lot of obligations under the Rome Statute. I don't want to spend too much time on all the procedural aspects of the International Criminal Court because I know we want to get to the cases, but I do want to touch on a couple different things that are very important for how the ICC operates and conducts its judicial proceedings. The first is the burden of proof. The burden of proof in ICC cases is the same as it is for US domestic courts. Defendants are presumed innocent until they're proven guilty, and the burden stays with the prosecutor at all times to prove that the defendant is guilty beyond a reasonable doubt. As far as sentences, the court may impose several different kinds of sentences. The first are fines. They can fine the defendants. Sometimes these fines will go to pay reparations for the victims. They can require the defendants to forfeit proceeds that they receive from their crimes. They can also sentence a defendant to prison, but there are some limits on this. They can sentence the defendant for any time period up until 30 years imprisonment. So no, there are no sentences beyond 30 years, except in very rare circumstances, the court does have the power to render a life sentence. This is based on a crime that would be extremely grave, and there needs to be individual circumstances, both with the individual defendant and with the crime that would warrant the life sentence. So far, the ICC has yet to impose a life sentence. And the next thing are fair trial rights. The ICC is very, very, very committed to upholding fair trial rights, upholding human rights under international law. The ICC is not just intended to kind of stockpile convictions and convict as many defendants as possible. It also serves as an example to the rest, to domestic judicial systems around the world. So it needs to make sure that it's really providing guarantees and providing rights for accused and defendants that line up with international human rights law to provide defendants with a fair trial. So there's a whole bunch of rights set forth in the Rome Statute for defendants. These include the right to be properly informed of the nature of the charges against them, the right to freely communicate with their counsel, the right to be tried without undue delay, right to examine witnesses against them, and a right to an interpreter. So very similar to a lot of the fair trial rights that we know from our domestic law. Okay, victim participation. Victims are entitled to play a fairly large role in the proceedings before the court. They can actually participate in the case and be represented by a specific lawyer. They must, in order to do so, they must apply with the court. But if the case is successful against the defendant, they could be entitled to recover reparations. So monetary reparations. These aren't always individual monetary awards that the victim gets to take home. Sometimes they're in the form of an apology in open court. Sometimes the money that's recovered from the defendant is dedicated to memorializing the victims and the victims of the crime and the victimized communities. And then finally, the ICC has a close relationship with the UN. However, the ICC is not the United Nations. As we talked about before, the ICC was created by a treaty, by an agreement among states. The United Nations were not involved in executing that treaty. Parties signed on to the Rome Statute themselves, and as such, the court is a completely independent, country-focused institution. It was not created by the UN. It's not a part of the UN. It's its own distinct entity. That being said, however, and this was a question I actually got at the end of last class, the ICC has a very close relationship with one organ or one unit of the United Nations, which is the UN Security Council. And for those of you not familiar with the Security Council, it's one of the 6 organs of the UN. It's tasked with maintaining international peace and stability and security. And the UN Charter grants it pretty significant powers to achieve this task. So it's allowed to authorize the use of force, So those things like invasions and attacks that we talked about with regard to the crime of aggression last time. It can create international tribunals to adjudicate atrocity crimes. So the UN Security Council has created a couple of the hybrid courts, as well as the two ad hoc tribunals, the ICTY and the ICTR. And it can also impose sanctions. So the UN Security Council is a pretty powerful entity. It's composed of altogether 15 countries. 10 of these countries are on a temporary rotating basis. They rotate in and out every 2 years. But 5 of these countries are what's called permanent members. They sit on the council forever. And they also have a very big advantage on the council in that they can basically put the kibosh on any resolution that they don't agree with. So these 5 permanent members have a veto power. So any resolution that's discussed before the Security Council, if they don't like it, it's not going forward. And so while the ICC isn't a part of the UN or a part of the Security Council, the Security Council does have quite a bit of authority when it comes to the ICC. This is especially obvious with the crime of aggression, because the Security Council can basically say when use of force is lawful or unlawful. But it also has a lot of authority with the ICC because the UN Security Council can actually refer cases to the International Criminal Court for adjudication. And in doing so, it can actually, I'm sorry, something just happened with my computer. It can actually kind of sidestep the jurisdictional limitations that are imposed on the court. Again, we'll get to that. Okay, very, very quickly. The life cycle of an ICC case. Investigations and cases before the ICC are generally extremely long. Trials last for years sometimes, and often investigations take several years. So I want to trace kind of pretty quickly through the 6 stages of a case before the International Court. The very first step is to open a situation. And in a few slides, we'll talk about how this is done. But essentially what happens when the court opens a situation is that it identifies a geographic region where international crimes have likely been committed. So where there has been an ongoing armed conflict or where there's been ongoing human rights abuses, it decides, okay, we're going to look at this, look at what happened here, see if there's any way we can prosecute the crimes that went on here. The second step, once the situation is open, the prosecutor conducts a preliminary examination followed by an investigation where she basically narrows down, digs into what evidence they find in the open situation, identifies what crimes have been committed, what defendants committed those crimes, and decides what cases she thinks she can bring to trial. Once she decides who the defendants are and what cases she's going to bring within that geographic situation, the pretrial chamber of the International Criminal Court, that unit of the judiciary that handles the issues that arise prior to trial, issues arrest warrants. And again, there's no police force to enforce those. So the duty to enforce those arrest warrants really lies in the state where the defendant is located. The state police will execute those warrants, transfer that defendant to the ICC, and then the defendant will appear in front of the pretrial chamber. And that appearance is called, or one of those first appearances is called the confirmation of charges hearing. And this hearing is very similar to arraignments in our domestic criminal process. Essentially, the charges are read against the defendant pleads guilty or not guilty, and the trial date is set. After that, we move on to the trial. Again, these are usually long. They're heard before a 3-judge panel. If there is a successful conviction resulting from the trial, the defendant will be sentenced. Following that, either the prosecution or the defense can appeal either the liability finding, the conviction, or the sentencing. And at the appeals chamber, these appeals are always handled by a panel of 5 judges and decided by majority rule. Whew, okay, that was quite a bit for our first question. So now we know what the ICC is, we know how it generally works, and we know kind of the cases that it handles. I want to stick with procedure for a little while longer before we get into the good stuff, but I do want to talk about the limits that are placed on the ICC. So our second question is, what authority does the ICC have to try international crimes? This is another one of those loaded questions. Because the ICC is intended, again, as a court of last resort, it has a lot of limitations that are placed on it so that it doesn't kind of intrude on domestic courts' authority or power. So we're going to go through now and talk about the 3 different types of limitations that are put on the court. And the first of these types of limitations is that a case, in order to be heard by the ICC, a case must fall within the jurisdiction of the court. And we're back to that term jurisdiction. Essentially what that means is the court's power to hear a case. So let's dive into that a little bit more. We're breaking this down even further. The ICC's power to hear a case is limited by 3 things within the Rome Statute. The first is time. The ICC can only hear cases that involve crimes committed after the ICC was established. So it will not hear any type of crime, any case involving a crime that was committed before July 1st, 2002. So any case heard before the court needs to involve a crime that occurred after July 2002. If a state joined the Rome Statute after July 2002, say it was on the fence about joining, it didn't get around to ratifying the Rome Statute until 2005, the ICC opens a situation in that country, the court will only be able to hear cases involving crimes that were committed after that state joined the Rome Statute. So crimes committed after 2005 in that case. So time is the first limitation. The second jurisdictional limit is the type of crime that can be heard by the ICC. Again, these are our 4 core crimes. These are, again, say it with me, genocide, war crimes, crime of aggression, and crimes against humanity. If it's not one of the, if it doesn't fall within those category of crimes, it cannot be heard by the ICC. And finally, location. The ICC can generally only hear crimes that are committed on the territory of a state party or by a national of a state party. So, for instance, one of the cases that was before the court involved the Democratic Republic of the Congo. The Congo is the DRC is a state party to the International Criminal Court, which means the court has jurisdiction to hear crimes that were committed on its territory. Alternatively, some of the crimes committed by the defendants were committed by Congolese defendants, but in neighboring countries like the Central African Republic. The court can still hear cases involving those crimes in the CAR because they were committed by the defendants of the Congo, a state party. So these are the 3 limitations on jurisdiction, but it's hands down not the only limitations. And actually, one more thing before we move on to the next slide, there is an exception to this location limitation. When the UN Security Council refers a case to the ICC, it does not have to involve crimes committed on a state territory or by a state national. It can involve crimes committed on a non-state territory by a non-state national. So the UN Security Council kind of has that added advantage in referring crimes to the court. Okay, second category of limitations. The case must be deemed admissible. And again, we have a fancy definition for admissibility with 2 separate requirements. In order for a case to be deemed admissible for prosecution, it must satisfy first what's called the complementarity principle. which again reinforces the court as a court of last resort. The case can only be prosecuted when a state with jurisdiction over the crimes is either unwilling or unable to prosecute. Driving that back home yet again. And then the second element of admissibility is that the crimes in the case must have a sufficient gravity to be heard by the court. So remember, the ICC is set up to hear only those most serious crimes that are of most concern to the international community as a whole. So these crimes need to be sufficiently grave, meaning they need to have a really significant impact, either by their effect or by the amount of victims that are hurt from the crime. And factors that the court considers in determining gravity include the scale, the nature, impact, and other conditions surrounding the crime. Okay, third and final category of limitations. Even if a case falls within the jurisdiction of the court, even if it's admissible, it satisfies the complementarity and the gravity principles, it can only move forward in the court if it's opened, if the situation in which the case is in is opened in one of three ways. And these three ways are, first, one we've already talked about, the UN Security Council refers the situation to the court. This is fairly rare. I believe it's only happened 2 times, one with a case in Libya and one with a situation in Darfur. And this is largely because of that veto power that I talked about before. So China, Russia, and the United States are all permanent members of the Security Council. They're not on the best of terms with the ICC. They're not going to either refer cases to a court they're not comfortable with or refer cases involving one of their allies. So this really limits the type of case that they'll refer. The second way of opening a situation before the court is that a state party itself actually refers the situation to the court. So it basically goes to the prosecutor and asks, I think it says, there have been crimes that have been committed on my territory. I want them looked into. Can you open a situation? And obviously the conversation doesn't go exactly like that, but that's the general idea. And then the third option for opening a situation is the most controversial. The prosecutor, if she finds a reasonable basis to open an investigation, can open a situation by what's called proprio motu authority, which is essentially just her inherent authority as prosecutor to open that situation. If she does this, she needs to get approval and authorization from the pretrial chamber to begin an investigation. So it's not just completely 100% her decision. She does need that pretrial chamber approval. Okay, question 3. Probably the trickiest and most loaded question I have on here. Has the ICC been successful? So this question is really difficult to answer, and pretty much everyone who's very familiar with the ICC will answer it a different way. But to put it in some perspective, the court was officially established in July 2002. So we are quickly coming up on its 20th birthday. And one of the easiest ways, and a lot of people choose to measure a court's success by this, is the number of convictions a criminal court achieves. So considering that the court has been in existence for 2 decades, I want you to take a second and think how many convictions you think that this this court has achieved. Since I can't see any of you, I won't be calling on anyone, but I would be interested to know your thoughts maybe later on. The answer is 5 convictions for core crimes that fall within the mandate. Obviously, this is a very low number given the amount of resources that the ICC has invested, as well as its 20 years of operation. The convictions are also not great when viewed in comparison with the convictions of the ICTY, the former Yugoslavian tribunal, which convicted something like 90 defendants, or the Rwandan tribunal, which convicted something like 60. But we also need to keep in mind that there haven't just been 5 trials. There have been a handful, dozens of cases that have been opened before the court, several different trials, some of which ended in acquittals, and some of which resulted in convictions that were overturned on appeal. And we'll talk about the challenges that the court faced and why it has this low number of convictions in a few slides. But before then, I want to go through what these convictions actually were. So the first conviction before the court was Thomas Lubanga. He was a Congolese warlord convicted of war crimes, including conscripting children. In 2012, he was the first person to be convicted and sentenced by the court. He was sentenced to 14 years in prison. Defendant number 2 to be convicted was Germain Katanga. Also from the DRC, the Democratic Republic of the Congo. He was a rebel leader in the Congo, convicted of war crimes, crimes against humanity, and targeting civilian populations. He was sentenced to 12 years. Third, we have Ahmad Al-Faki Al-Mahdi. He was a member of an Islamic rebel group in Mali. He pled guilty without a trial, and he was convicted of war crimes, including the first ICC conviction for directing attacks against religious and historic buildings, destruction of cultural heritage as a war crime, which was a big accomplishment. He was sentenced to 9 years. So already we know that the court can sentence life sentences up to 30, as well as sentences up to 30 years. These sentences were not too hefty in light of that. Fourth, though, we have Bosco Nataconda. Again, from the Democratic Republic of the Congo. He was a leader of the Congo Liberation Movement, a rebel group convicted of war crimes, crimes against humanity. He was also the first conviction for sexual slavery and sexual-based violence before the court, which was a huge success. And that case was really interesting as well, because it showed that you can be convicted for war crimes of sexual violence against both men and women, so members of the opposite and of the same sex, as well as members of your own force. So Nataconda was convicted of committing war crimes, committing crimes of sexual violence against members of his own force, and this was a really heavily debated topic, but ultimately the court found that to be a war crime. He was sentenced to 30 years, so he got the biggest sentence out of all of them, still no life imprisonment, however. And finally, very, very recently, we had the trial of Dominic Ongwin. He was a brigade commander for the Lord's Resistance Army, which was a rebel group in northern Uganda, and he committed a variety of war crimes and crimes against humanity. He was convicted of 61 charges in all. On its face, his case looked very similar to the other men's. However, his was extremely interesting because he was actually a child soldier. He was abducted at the age of 9 while walking to school. And after that, he became firmly established in the Lord's Resistance Army. He rose through the ranks and engaged in a lot of war crimes and crimes against humanity. The court considered his background in the sentence and the conviction, but ultimately found that he was guilty for these crimes, and he was sentenced to 25 years in prison only last month. So very recently, his conviction is still pending appeal, so things could change. So you might have noticed some commonalities among all of these convictions. The first is, of course, they're all men. And that's not uncommon. All of the suspects, all of the defendants before the court, as far as I know, are all men. It's very rare to see a woman before an international criminal court. And the second commonality is that they're all from African countries, which is another big problem that we're going to touch on. So is the court successful? I think so. In my personal opinion, I believe it is. Could it do better as far as convictions? Yes, I do think it can improve. However, convictions are not the only way to measure the success of a court. Instead, we need to look at all of these other benefits that the court is engaging in and the goals it's achieving. It's prompting domestic courts to act. So through its complementarity principle, it's essentially providing somewhat of a threat. So domestic courts, you need to prosecute these crimes or we will step in. It prosecutes crimes that would otherwise go largely unnoticed and largely unpunished, which is instrumental to recovery and healing in post-conflict communities. It draws attentions to victims and the crimes committed against them, and also develops a historical record of these crimes, which otherwise may kind of be lost in the cracks of history. And finally, there's mixed evidence on this, but there is evidence to suggest that it has worked to deter atrocities. So all in all, yes, I do think the court is successful. Again, there are varying opinions on this, but I think we need to look beyond just the convictions themselves. I also think the court is successful because of the many, many challenges that it faces in its day-to-day operation. The first is budgetary restraints. I mean, it sounds kind of silly, but the court is like any institution. It has a strict budget that really hasn't been expanded to take into account the court's expansion. So it works under significant limitations. The second are prosecutorial mishaps. I've included all three pictures of the former, present, and future prosecutor here. I mean, I think we need to remember as well, the court is simply basically a teenager at this point. So this was the first court of its type, and the prosecutors kind of encountered some problems along the way as far as evidence and witness tampering, but they've really come to learn from these challenges. They've created plans, they've conducted outside expert reviews on how they can improve, and they're really committed to moving forward. Another challenge facing the court is its overemphasis on Africa. It got a lot of flack because, as you could see, all of its cases, all of its convictions were involving African countries. And one of the reasons for this was that these African countries had self-referred those cases to the court, and also because there was a lot of violence happening in Africa that needed to be addressed. However, in light of this criticism, Fatou Bensouda, the current prosecutor, began expanding her investigations geographically. And using her own proprio motu power, she's opened 3 current investigations that have proven very controversial. And there's other open investigations as well, but these are kind of the 3 that are most on my radar and on many people's radar. The first is Bangladesh. I mentioned the Rohingya Muslims who've been mistreated by Myanmar forces for quite some time now. The court recently found that it has jurisdiction over crimes committed against the Rohingya, but only the crimes of forced deportation. And they found this because while the crime began on Myanmar territory, it ultimately ended with the transfer of these Rohingya onto Bangladesh territory, which is a state party. Another investigation involving a non-state party is Palestine. So the prosecutor opened an investigation into violence that occurred in Israel during the 2014 war, as well as in areas of Israeli-occupied Palestine in the Gaza Strip from 2018 onwards. And while Palestine's status as a state is disputed, it is a member of the ICC. Israel is not. And the court found that because of Palestine's status as a state party, it had jurisdiction over these crimes, and the prosecutor is moving forward with the investigation. The third and final and most important, in my opinion, is the open situation and current investigation into crimes committed in Afghanistan. And this involves crimes committed during the Afghanistan conflict from 2003 onward. It looks at crimes committed by the Taliban and other terrorist groups, the Afghan National Security Forces, and finally the US CIA and military officials for alleged crimes of torture and mistreatment of defendants in Afghanistan prisons and in other black ops sites. Which brings me to my final big challenge facing ICC, which is a lack of cooperation. So lately, the ICC has come under fire for the 3 investigations I just showed you, as well as for some other reasons. But lately, one of its biggest enemies is the United States, which, as the most powerful country in the world, is a pretty formidable opponent. I have 15 minutes left, so I'm going to try to run through this final question as quickly as I can to save time for questions. But I want to address the United States' both past and current relationship with the International Criminal Court. I said at the beginning of this presentation that the US voted against the Rome Statute. It is not a member of the ICC, so no spoiler alert there. It is not a state party, which kind of comes as a surprise based on my discussion during last class, where the US was really kind of the driving force behind the Nuremberg Tribunal, the Tokyo Tribunal, and very active in the 2 ad hoc tribunals, as well as hybrid courts. But when it came to the ICC, the story really changed for the United States. It supports international criminal justice and was originally supportive of the idea of an international criminal court, but where it really got hung up was the fact that the United States itself could be found guilty of committing war crimes or crimes against humanity. And this was because at that point, and still currently, the United States is often seen as the world police. We are meant to step in and help solve humanitarian crises. And if we are punished for stepping in and doing this duty that we owe the world because of our power and our military force, well, that's not really fair. So, as I mentioned, US voted against the Rome Statute, did not join the court, and this was under the Clinton administration. But ever since then, under every single president, there's been somewhat of kind of a tense relationship. There's been ebbs and flows in this relationship based on the administration in power. But the US and ICC has never really been close, that I would say. But this really hit kind of a focal point with the courts, with the prosecutor's opening of a situation in and a continuation of her investigation into Afghanistan. And when the prosecutor indicated her intent to open the investigation in Afghanistan, the Trump administration was in power, and they responded pretty forcefully. They engaged in several really high-profile speech, basically denigrating the court, saying it was overstepping, calling it a kangaroo court without authority, and saying it wasn't entitled to prosecute the United States because the United States was not a state party to the Rome Statute. However, once the court found that it had jurisdiction and authorized the prosecutor to move forward with the investigation, things really hit a high point and took a turn. President Trump issued an emergency order in which he declared an executive order, in which he declared a national emergency presented by the ICC's investigation and authorized and later imposed sanctions on Prosecutor Fatou Bensouda, as well as another high-ranking member of the ICC prosecution team. And this was huge. I mean, it was the first time, a lot of you probably remember, I think this was in June last year. It was the first time that the US has sanctioned a court, or really anybody that's not a war criminal or a dictator or a warlord. So this was really monumental. When Joe Biden took power, he revoked the executive order authorizing sanctions, but he made very, very clear that he does not support the ICC's investigation, and that the United States will not cooperate with that investigation into Afghanistan. So that's going to be a really interesting case to follow, to see if the ICC can succeed without the United States' help. So I know that was a lot to cover in 50 minutes, but I'm really excited to hear your questions. I'm happy to talk through any of this further. Again, this is my email address. I received a few emails last time, but really, if you have any questions or want to talk through this, please do not hesitate to contact me. And let's see if I can stop this. Christian, are you able to
Yep,
connect?
I'm here. Yep.
Perfect.
So yeah, we got a few questions that I think would be great if you could follow up on. The first
Sure.
one touches on one of your earlier slides about the makeup of the court with all the different intricacies, especially with the Office of the Prosecutor. But one of the questions was, how are the investigators, judges, prosecutors, and defense teams appointed? We partially answered this by saying some positions are just like any organization where you can apply, but maybe you can touch on those other portions that aren't necessarily hired based on application.
Yeah, so you're totally right for things like lower level positions. So applying to the prosecutor's office, for instance, that's just done through a UN job application. But things obviously change when you get into those high ranking positions. So the chief prosecutor, first of all, as well as all of the judges that sit on the ICC, are actually elected through the Assembly of States Parties, which is basically like the legislative branch of the ICC. I didn't mention it because it's a bit distinct, but not. And it's composed of representatives from states parties, and they have a huge, very long procedure requiring public interviews and long applications, private interviews, public hearings, all of these different things to make sure that the prosecutor and the judges are qualified and willing to do what it takes. But the defense counsel is its own separate thing. So there is no defense counsel unit. Like there is an office of the prosecutor, there's no office of the defense in the ICC. So those counsel are just independent lawyers. They are hired by the defendants themselves or the defendants' governments, and they are not technically a part of the ICC. So hopefully that answers that.
Yeah, and to go off of what you just said, are you saying that there's no, right to counsel as there is similar to in, U.S. domestic constitutional laws, or is that something that's discussed at all?
I'm not entirely sure. In the Rome statute, it says that that defendants have a right to choose their counsel. I don't think that there's ever been an issue where a defense had to get something like a public defender or something like that, because these cases are so high profile that international lawyers are very excited to take them on. So I think they would take them even pro bono. So I'm not entirely sure about that, but I mean, they have a right to be represented. I just don't know what happens if they don't have the money.
Okay. And then the next question we have is, what crime could someone commit to get a life sentence? Or I'll add on to that, is just the life sentence an option open to the court on like a discretionary thing and not necessarily one where it says X crime gets life sentence?
Right. So what the Rome statute says is basically the court has discretion exactly to impose a life sentence when it finds that the individual circumstances and the circumstances of the crime justify it. Again, we've seen some pretty heinous crimes before the ICC, war crimes, crimes against humanity. So it's unclear exactly when, if ever, the ICC will determine that a specific crime or totality of crimes warrants a life sentence, but there is no set like this crime has a mandatory life sentence. There are no mandatory sentencing requirements for the ICC.
All right, and then the next one concerns you had the slide on current investigations, and it's a question on, maybe you can answer if there is one open on maybe things that happened under the ISIS caliphate in Iraq and Syria. Yeah,
so there was an investigation involving British soldiers, crimes committed by British soldiers in Iraq, but it ultimately closed. It did not proceed to trial. There are no other investigations that I'm aware of that involve Iraq or Syria, because neither Iraq nor Syria are a party to the Rome Statute, so that presents a lot of jurisdictional issues. However, there are currently UN independent mechanisms that are investigating the crimes of ISIS and that have been committed in Syria, and there's hope that something like an ad hoc hybrid mixture court, standalone court will be set up to prosecute both of these crimes, but it's not looking like the ICC will be able to handle those.
Okay. And then there's a question asking for your personal opinion, but I think I'll paraphrase it a little bit, and maybe you can explain the international criminal legal community's discourse on it. But is there any discussion about changing or amending the relationship between the Security Council and the Criminal Court, as obviously the political nature of international law in general may cause issues of justice not being pursued, or possibly political motivations behind when and when not to request assistance from the court?
Yeah, so I mean, I think my opinion jives with a lot of international legal scholars' opinion on this. I think the Security Council relationship with the ICC is extremely problematic. I think generally, most in academia think that the Security Council in and of itself has problems with permanent membership and the veto power. I mean, just in the context of the International Criminal Court, exactly as that question said, it has prevented referrals. So for instance, you had asked about Syria. Even though Syria is not a state party to the Rome Statute, if the Security Council agreed that the Syria case should be referred to the ICC, it could essentially bypass that jurisdictional limitation. However, Russia and I believe China are not going to vote for that because those are their allies. And they've blocked a referral of Syria to the ICC on several occasions. So I certainly think it's problematic. Do I think it's going to change? Unfortunately not, because I mean, these are the most powerful nations in the world. So they're not going to voluntarily relieve themselves of their permanent status or their veto power in the UN Security Council. So I think any attempt to change that is going to be an uphill battle.
Yeah. And then there's one in the chat, it's not in the Q&A, and it says, do you think the ICC will expand the crimes? So maybe, do you think it will expand the crimes under those 4 crimes you talked about? How would it go about doing that? And then specifically in this question, it talked about, is there any discourse currently about those additional crimes being maybe some against the environment, as that becomes a more pressing issue or a part of the political international discourse?
Yes. So I'm not sure the answer. I don't know if the ICC will expand. I think it's very, very difficult to amend. It's a long process to amend the Rome Statute. However, there has been academic discourse about expanding to environmental crimes, specifically to ecocide is how they refer to it. There's been a lot of talk about that among academics and among practitioners, and also going back to one of the questions from last week as well, issues of cyber crimes. So I do think, I agree that the Rome Statute should be amended to incorporate these. However, I'm not sure what the likelihood of that will be.
And there is a question in the Q&A about, has the budget ever made any problems? And maybe you can be specific with it. Was there any statements that were made by the Office of the Prosecutor where it was like, look, we would investigate this, but like the capacity, or would those conversations probably be kept internal on deciding that stuff? I
am not aware of any public discussion of that, any public statements made by the prosecutor as far as the budget goes, but I do know that the budget is it's funded by the state's parties. So, and it really, I don't think has changed too much over the years. I know that I don't know of any public statements about not being able to prosecute crimes because of the budget. I do know that there was a lot of grumbling from the judges about being paid too low because of the budget, which is another issue entirely. But I think the budget does cause a lot of behind the scenes issues. And in kind of a different but related issue, one of the hybrid tribunals, the Special Tribunal for Lebanon, that's currently investigating and prosecuting crimes related to a bombing several decades now ago against the sitting Lebanese prime minister at the time. They actually just publicly released, they've run out of money, and that at this point they had to halt pretty much all of their proceedings. They can't move forward with the trial that they had scheduled for June, and their future is uncertain. So, I mean, that of course is not the International Criminal Court. It's not as high profile, but if it can happen to that hybrid court, then theoretically it can happen to other international courts, which is concerning for sure.
Yep, exactly. And with that, we're at 5 p.m. Eastern, which is our stop time. Sarah, I want to thank you again. It's been so informative, and I really appreciate it. I think I speak for everyone. Thank you for sharing your expertise and knowledge. And I know I learned a lot, and I hope everyone else did as well. If you have any other further questions, I ask that you refer to Sarah's email address, or you can, of course, email me at christian.jorgensen@redcross.org. In a follow-up email from Zoom, I will be sharing the slides from this presentation, as well as a link to the recording should you wish to share it with other people. Thank you very much, everyone, for joining us, and thank you again, Sarah. It's been a pleasure.
Thank you, Christian, and thank you, everyone, for coming.